Hi, this is Mark Wallstrom, and welcome to Speaking of Settlements, a featured broadcast on the Legal Broadcast Network. Well, today my guest is somebody who barely needs introduction in the structured settlement world. It's tax attorney Robert Wood of the law firm Wood, LLP in San Francisco. Rob, thanks for joining us today.
Thank you, Mark.
Rob, what I wanted to discuss with you today is the regulations that came out last week by the IRS, Final Regulations, Final Comments on a tax law change from 1996 on Section 104 that really got into the definition of personal physical injury and the whole changes that were made in 1996 to create more of a bright line as to what qualified as tax-free payments and what didn't. Rob, could you talk a little bit about what the IRS ruled last week?
Sure. Well, I think the major impact is minor. That is, I don't think that there's a big impact. I've gotten a number of calls and emails from people thinking that when the IRS comes out with final regulations on something, and something as important as Section 104, the personal physical injury tax exclusion, that there'd be major developments, and there really aren't. These regulations were proposed back in 2009, and they were just finalized, Mark, as you said, just this month, just recently. Unfortunately, the one topic they do address is, do you need to have a claim based on tort or tort-type rights? And the answer is no, you don't. So the sole focus is if you're evaluating whether a claim results in tax-free money, is were the injuries, was the payment for personal physical injury or physical sickness. And there's no discussion in the final regulations, and there wasn't any in the proposed ones, about exactly how physical it has to be, what that means, what physical sickness means. No definition. So this tort or tort-type rights test being eliminated is good. It means that no-fault statutes that you have in some states, it means that it's not relevant anymore to look at, as much of the case law had done, including the U.S. Supreme Court in the Burke decision in 1992. They had looked at this question of the panoply of remedies typically available. Is it tort-like or not tort-like in scope? And if it's a statutory claim for discrimination or something, all that stuff's out the window. The sole focus is this an injury that's personal physical injury or personal physical sickness? That's what counts, and that is still up in the air.
Rob, and one of the other things that brought up, and that I know they commented on, and this was really related to the public comments that were allowed about a year ago when they held a hearing on this, I guess almost 2 years ago now, on the issue of single claimant 468B, as well as an expansion of the definition of things that would qualify as physical or personal injury. Could you address whether or not they brought these things up, or whether they deferred to speak about them?
The latter. They deferred. They basically didn't say anything about that. I think you can get, and I have a copy, Mark, I'm sure you do too, of the hearings back in, I think it was 2010 or 11, I don't remember when, 2010 I think. On these 2009 proposed regs, and you're absolutely right. There were questions raised about wrongful imprisonment recoveries and molestation recoveries, and that is, are those personal physical injuries or not? How do you, as a plaintiff, as a structured settlement broker, as a lawyer, as an insurance company writing structured settlement annuities, how do you evaluate whether you do or don't meet the 104 test? It's a rather critical question, and I think the answers, Mike Montemurro from the IRS, who provided, I thought, some good answers in that hearing, is basically that, you've got to look at a case-by-case basis in terms of false imprisonment or wrongful imprisonment recoveries. The IRS he said, I believe, and this is all non-binding, of course, but said that he didn't think the IRS had ever really gone after anyone for not paying taxes in that context. And of course we know from other sort of unofficial guidance that has come out that they generally look at whether there has been personal physical injury, and they kind of use that as the hook to try to exclude something. Unfortunately, though, I mean, none of that is official guidance, and these regulations simply don't address it. The same thing, I think, even more clearly with the single claimant issue. Single claimant issue is a really different code section entirely. In fact, a couple of code sections unrelated to Section 104. So I don't think that it was reasonable to expect, for anyone, to expect that guidance would come out in this context.
Rob, as part of this whole process, I know there was public comment that was brought up, and one of the things that was discussed was whether or not the Treasury would address single claimant 468B, as well as an expansion of the definition of what personal physical injury is. Did they comment on this? Did they defer, or was it just left unsaid as part of this final regulations?
Yeah, Mark, I agree with you. I think it's reading too much into it to proclaim victory, or proclaim the one can read something from these tea leaves. I think that's hard, or maybe even impossible to do.
Rob, what lingering issues are left for the structured settlement industry and professionals as a result of this ruling? Or does this really kind of button everything up and tidy things up regarding Section 104 and taxation issues in your mind?
Well, I think, yes, there are issues, and they're, I think, more than lingering. I think the major issue, which I think the structured settlement industry has always, in some ways it's sort of the elephant in the room, is what is excludable and what isn't. And we know that is sort of a facts and circumstances analysis, but just saying that is hardly enough. I think that brokers, and most especially the life companies, need to have kind of a methodology for evaluating how much is enough and what they can write as a qualified assignment. And I mean, I don't know if it's a bomb waiting to go off. That may be, sort of hyperbole, but it's tough, and the IRS, and I don't want to criticize them. I mean, they haven't done a good job with the issue, but it's a tough issue, and I guess it has to be largely facts and circumstances, but it seems like there ought to be more guidance than there is.
Rob, really from your standpoint, I mean, and my standpoint as well, the brokers sometimes tend to be a little bit sloppy. Life market compliance, I think, tends to be a lot tighter. In this ruling, in these definitions, in these areas, particularly in the issue of emotional damages, I mean, they really went out of their way to make clear that emotional damages, which I think we all knew, were and are taxable, but they kind of used that as the bright line or the key focus in this ruling, didn't they?
Well, I think documentation is key. I'll try to just say what I do. And first of all, Mark, you're right that this final regulations, which has a few lines saying, frankly, it's not new news. It's simply restating what was very clear in 1996 in the legislative history to the change in the law, which is, look, if you've got emotional distress damages, those are taxable. I mean, kind of bright line, black letter law, emotional distress damages are taxable. I mean, that was the thing, the primary thing, which they were going after in the change in 96. Right. Emotional distress damages, and of course the primary culprit, the IRS thought, and I think probably rightly, was the employment case. So, you have a big messy employment dispute involving a person, and they, are getting a $500,000 settlement, and $200,000 of it is wages. Let's say that everyone agrees is sort of back pay, front pay, or something. What's the other $300,000? Well, I mean, the logical thing, which people did for decades, was it's emotional distress, and therefore, it ought to be tax-free, we said prior to 96. So, I mean, everyone knows that. I guess what's now clear, of course, and it almost sounds metaphysical, but emotional distress unconnected with physical injury, well, that's taxable, we know that, but emotional distress arising out of physical injury is tax-free. So, I mean, if you, when you say you're a settlement planner or a lawyer and you're trying to decide what, how much belongs in what category, I think you need to have some file memos, and these can be privileged documents, but something from someone, and I guess if I'm involved, it would be from me probably, analyzing what we think the claims are, how much we think is reasonable. Are there medical records or psychiatric records that help? Is there a damage study that helps to sort of parse the number? Because I think it's real hard to just say, it's X, Y, and Z, and we'll put a third in each category. And it's in many cases it's indefensible to do that. So I think documentation, declarations from the client, from healthcare providers that are put away, that I may put in my file and don't intend to show to anybody, but if I ever need to show them to the IRS, for example, I can, showing kind of how we got to a particular number.
So Rob, in summary, I think when we look at this, we will have a copy of your Forbes article, which you recently published on the same ruling, on our website as well as on the Tax Law channel. This was really no big win for anyone on the issue of 468B, but there was no big loser as well. I mean, the IRS just punted it. We didn't get any expansion or greater clarification on the topic of let's say wrongful imprisonment and sexual molestation cases, so those really weren't addressed, unfortunately. But in general, it did tidy some things up, it did neaten some things up, but really not that big of a deal at the end of the day, other than the fact that if we should probably use this as an opportunity for people to, once again, tighten up their process, be careful about how they document, and again, thank you, Rob. I appreciate you being part of what we do here, and appreciate your commentary every single week.
Thank you, Mark.
You've been watching Speaking of Settlements, a featured broadcast of the Legal Broadcast Network. I'm Mark Wallstrom. Look forward to seeing you again next week here on Speaking of Settlements.